with the due permission of the Honorable Court, may prosecution proceed?
Proceed. Continue.
I, Prosecution Officer R.N. Agarwal, on behalf of the State of Madhya Pradesh, presenting the case before the Honorable Court. Government of Madhya Pradesh through SHO Police Station, City Kotwali, Rewa versus Arun and Amit. As per the prosecution, the accused persons are charged with section 296, 333, 117 to 115 to 351, 3. Read with section 35 of BNS 2023 registered under crime number 946/20 for causing injuries to complainant. Summary of the case is as follows. On 14/12/2020 in morning about 8 a.m. informant Bittu lodged a FIR with police station City Kotwali, Rewa, as he resides in village Kharkoti under Thana Kotwali, Rewa. So the incident took place on 30/11/2020 at about 7 p.m. in the evening while Bittu was resting in his drawing room. Accused Arun and Amit started to abuse Bittu when he went out to see what is happening outside. Accused chased the victim with lathi inside the house and assaulted Bittu, resulting bleeding injuries over head and on right arm. When Babli, wife of Bittu, tried to save him, she was also attacked by them, sustaining bleeding injuries over left arm and leg. When other family members and neighbors came to save Bittu and Babli, they intimidated Bittu by threatening to cause death and fled away. Both were admitted to Bichya Hospital, Rewa after discharge on 4/12/2020. Bittu with plaster in his right arm and bondage over his head, along with wife to lodge FIR. Thereby police registered a case under various sections with crime number 946/20 as follows. Section 296 for obscene acts and songs. Section 333 for house trespass after preparation for hurt, assault or wrongful restraint. Section 117 to BNS 2023 for voluntarily causing grievous hurt. Section 115 to BNS for voluntarily causing hurt. Section 351(3) of BNS 2023 for criminal intimidation. Read with section 35 of BNS 2023 for common intention. So there are various testimonies of witnesses. So prosecution has examined as many as 5 witnesses. The first one, prosecution witness Bittu, the main complainant. So he stated that on the date and time of incident, the accused Arun and Amit entered his house and assaulted him over right arm and right side on the head with lathis. And when his wife Babli, prosecution witness 2, tried to save him, both the accused persons also gave lathi blows to Babli. When his family members and neighbors came and shouted over to the accused Arun and Amit, they fled away from the spot of incident. The report was filed by him in Exhibit P1 and spot map prepared before him in Exhibit P2. He remained admitted in hospital for 3 days because his right arm was fractured. Thus, the testimony given by the prosecution witness 1 in open court is well corroborated by the FIR and the witnesses that accompanied him during registration of FIR. So the prosecution witness 2, Babli, wife of Bittu, she completely supported the prosecution version to the extent of Bittu's prosecution case, as she was also a victim of the case because she suffered grave injuries caused while safeguarding her husband, the complainant. So there is one case in Abdul Saeed versus State of MP. Supreme Court held that where witness to occurrence was himself injured in the incident, testimony of such witness will be considered reliable as he comes within built guarantee of his presence at the crime spot. Prosecution witness 3, the real brother of complainant residing in his neighborhood. In his testimony, he admitted that during the incident he was at his residence and suddenly he heard the accused Arun and Amit abusing extensively to the complainant. He came out to see what had happened, where he noticed accused person caused lot of injuries by chasing the complainant. Thereafter, he enumerated the incident in support of Bittu's testimony. There is prosecution witness 4, who is an expert doctor. He presented their MLC report, Exhibit P3, that proved that Bittu complainant sustained bleeding injuries over head and on right arm. Thereafter, X-ray report by Bichia Hospital, Rewa, in Exhibit P5 clearly specifies that the complainant suffered fracture in his right arm and suffered major injuries on his head caused by hard and blunt object like lathi. MLC report Exhibit P4 presented by expert doctor specifies that the co-victim Bubbly, wife of Bittu, sustained bleeding injuries over left arm and right leg. Here, the doctor is an independent witness and his testimony is very well corroborated the incident so enumerated by the victim. It proves that the injury so caused by the accused person was intentional and so severe and caused by Lathi's blow of them. Prosecution witness 5, investigating officer. He prepared the spot map and also recovered hard and blunt lathis from the victim house at the crime spot that was left by the accused while retreating from the crime scene. So on further examination of lathis seized at crime spot by the investigating officer showcased that the fingerprints found on the lathis are belong to the accused persons. So my final argument here is, finally, with the testimonies of the complainant and his wife along with his real brother residing in his neighborhood, that the accused person created lot of public annoyance by using excessive abuse along with intimidating the complainant by threatening to cause death to his person. Also, the MLC report duly submitted by the expert doctor along with X-ray report of Bichia Hospital clearly specifies the injuries so suffered by the complainant is due to extensive brutal beating of hard and blunt object. The doctor report is well corroborated by the testimony of investigating officer who seized lathis at crime spot having fingerprints matched with the accused persons relevant under section 160 of Bharatiya Sakshi Adhiniyam 2023. Thus, the prosecution has established his case fully by proving all the charges under section 296, 333, 117(2), 115(2), 351(3) read with section 35 of BNS 2023. There is no ground to disbelieve the testimony of victims. Thus, both accused persons are liable to be convicted by the Honorable Court.
Honorable Court, here Purvi Agrawal. I am representing as a defense advocate of Arun and Amit, against whom a false case is instituted by the prosecution advocate on the behalf of both complainant Bittu and his wife Bubbly. My lord, may I start the argument on this case? Defense plea is that my client only talked about the drainage water was coming from the complainant's sewage into their plot, which made the plot a marshland. Instead of dealing with this arrangement, they launched a false complaint against my client by taking advantage of this situation because recently Bubbly and Bittu fell down from new purchased motorcycle and driving it without any license, and due to the past issue between them, both complainant institute false case against my client. Defense argument is that my prosecution advocate presented prosecution witness first as a Bittu, prosecution witness 2 as a Bubbly, prosecution witness 3 as a Mohan, real brother of Bittu, prosecution witness 4 as Dr. Vikash, prosecution witness 5 as an investigation officer named as a Sanjay Dutt. So I want court to note down that all the prosecution witnesses are the relative of complainant Bittu and Bubbly. There was no independent witness represented in the prosecution agreement. Dr. Vikas as a prosecution witness 4 and investigation officer Mr. Sanjay Datta as a prosecution witness 5 to be involved in this case with very bad intention. Due to this, their false statement and mistake done in the investigation, so this case allegation should be rejected after the consideration of defense evidence. My lord, my first defense was against the complainant Bittu, prosecution witness first, states in his statement that the date on 13/11/2024 around 7 p.m. he came from the office to his home and resting in the drawing room. Sir, prosecution witness statement was totally false because 13/11/2024 was a public holiday. How he came from the office on that day? My second defense against Bittu was that Bittu recently purchased a new motorcycle on the date 25/11/2024. The date was very important because he was driving bike without any driving license with his wife that caused the injury. Due to the past conflict with each other, Bittu filed a false case against my client by taking this golden opportunity for his revenge. My next defense against Bubbly, Bittu's wife, is a prosecution witness 2. My first defense against Bubbly is that, sir, after receiving MLC report from the Vichya hospital, it get to know about that Bubbly got only simple hurt, but Bubbly did not inform the police about she got a simple hurt, not a grievous hurt. This false information of Bubbly shows that the intention is evolved. Second defense against Bubbly is FIR was filed on the 4/12/2024, but incident happened on the date 30/11/2024. There was a delay of 3 days in filing first information report in the police station by Bittu and his Bubbly, which gave the time of both of them to conspire the case and producing false and counterfeit evidences to the court. From this, we can conclude that the malified intention involved in the case on the behalf of Bittu and his wife. There was one case involved, that's Thulia Kali versus State of Tamil Nadu, 1972, Supreme Court 393. In this case, court may suspect the case was fabricated after the consultation after the victim delay in the filing FIR without any valid reason, especially in the hurt and the assault cases. My next defense against Mohan, Bittu's real brother, as a prosecution witness 3. My first defense against Mohan is that Mohan is the real brother of complainant Bittu who testified the case. In the prosecution argument, there was no independent witness. All the witnesses of the are relative of Bittu, either as Bittu wife, either Bittu brother, either as a Bittu family doctor, and Mr. Sanjay Datta, who is the investigation officer of this case, is very close friend of Bittu. At the time of incident spot, other neighbors are also present there. Why they not testify in the court? I want to ask the prosecution advocate, why you not include the neighbors in the testification? Under section 146B of the Bharatiya Sakshya Adhiniyam 2023 talks about the position of witness in the life and his relationship to the party to the proceeding. This gives a right to the defense to question a witness about their relationship to the case, like whether witness is relative friend, servant, employer, or any enemy of the party to find out whether they are biased, interested, or partial. As held in the Dilip Singh 1953 and State of the Rajasthan vs. Kalki 1981, relationship is not disqualification. What matter is reliability and to test credibility, impartiality. My second defense against Mohan is Bittu and his brother are habitual offender. In the past, they filed many false cases against person to get compensation from the case and teasing, disturbing the personal peace. There are many evidences related to a false registered case by both complainant. My lord, my client have no such previous record of crime, treated as a reputable person in society and by their neighbors. My next defense against Dr. Vikas, who is the prosecution witness for. My first defense is Dr. Vikas has done a medical examination of Bittu and his wife Bubbly and submitted X-ray report of Bittu. MLC report exhibit P3 and P4 in which there was no mention about date and time and also signature of doctor in his report. To get to know about when the such report is prepared, which create doubt about the report preparation by the Dr. Vikas and showing the involvement of doctor in this case, because Dr. Vikas is very close friend of Bittu and helped the complainant to conspire the case. Second defense against doctor is as family doctor of Bittu. Dr. Vikas report state that Babri wife of Bittu had injury in her right hand and right leg, but in the prosecution statement state that Babli injury was caused in the left hand and left leg. Both statements are contradictory in the nature, which show the false testimony of Bittu. My last defense against Mr. Sanjay Datta as a prosecution witness 5 is Mr. Sanjay Datta has done the investigation in this case in which he didn't disclose fully all the proceeding of the case. And second defense against doctor against investigation officer is investigation charge sheet mentioned that the lathi was found at the incident spot, but as per the forensic report, there was no fingerprint of accused Arun and Amit on the lathi. So, how the prosecution concluded that the lathi was used as the weapon for the hurt and assault, and prosecution argument state that the fingerprints are found, which showing involvement of investigation officer in matter. I want to present defense evidence to court that both accused Arun and Amit denied the whole allegation imposed by the complainant Bittu, and one of the neighbor of Bittu also complained about the drainage water is coming from the Bittu sewage, which makes the my client plot marshland. Second defense witness is Manvi, who was also aggrieved by the complainant for instituting false case against them to get the compensation. I want to quote to know about that. As per RTO office record, no driving license is issued to the Bittu, so we can conclude that he doesn't know how to drive, and injuries are caused due to his mistake only, not by harsh beating by accused Arun and Amit. Bittu is covered under the Motor Vehicle Act 1988 Section 3, which established valid driving license is necessary for driving a motor vehicle on any public road. Second defense evidence is that at the time of incident, accused Amit is in Mumbai for some business too. So it creates doubt of section 9 of BSA, plea of alibi, then facts not otherwise relevant become relevant, means both statement of Amit in present in incident and Amit is on business too are vice versa. Next defense witness is prosecution witness don't include any independent witness who don't have any relationship with Bittu complainant. Defense counsel present neighbor of Bittu as an independent witness who agree with my client statement. In the last defense evidence, I want to place in court forensic science laboratory report which show no fingerprints of the both accused on the lathi is found. In the last, I want to conclude that there is a variation in the medical examination. No independent witness has been examined by the prosecution. There is considerable unexplained delay in the lodging FIR. The story of prosecution is false because 30 November 2024 was a public holiday. Hence, no question of coming from the office by the complainant arises. Sir, hence the charges of section 3 subclause 5 were no premeditation of minds for the common intention. Charges of section 296 no obscene act and seen at the incident spot. Charges of section 117 subclause 2 and charges of section 105-15 subclause 2 injuries are caused due to the fall down from the bike. Charges of section 333 no such trespass has happened. Charges of section 351 subclause 3 of BNSS no evidence of such restriction is found. So all the false allegations imposed by the prosecution advocate are meaningless, misleading the court. Due to the preponderance of evidences, there was no ground for instituting this case. So I am kindly requested to this court to respectfully release and acquit my client from all the false allegation and demanding compensation for false case against my client for wasting valuable time of court and Arun and Amit. Thank you.
My lord, may prosecution proceed. So first is defense counsel stated that on 30/12/2024 there was a public holiday, but the complainant being a municipal officer, thus there is no concept of public holiday. Although being a Guru Nanak Jayanti, there was more hectic day for a complainant. Second one, although the witness, prosecution witness 2, his wife, and prosecution witness 3, real brother of victim, are relative witnesses, but still they are relevant, as there is one such case in Union of India versus Savita Sharma 1979. It was held that if witness is relative of a person who produces him, his statement cannot be disregarded only for that reason. The third defense was defense of plea of alibi taken by the defense counsel needs to be dismissed by the Honorable Court, as it was clear from the testimonies of prosecution witness 1, prosecution witness 2 and prosecution witness 3 that the accused were there and they himself seen them. Fourth defense plea was that the complainant have no driving license. But as per section 3 of Bharatiya Sakshi Adhiniyam 2023, the evidence can only be given of facts which are facts in issue and relevant facts. Here, driving license is neither a fact in issue nor a relevant fact, thus needs to be disregarded. Fifth, under section 114 of BNS 2023, it is crucial to have any bodily injury for prosecution of hurt. Thus, it is immaterial whether it hurts on left arm and right leg or right arm and right leg. And from the testimonies of prosecution witness 2, prosecution witness 4, and even the defense counsel admitted that the injury was caused. It may be clerical error and no more than that. Next, defense plea is injuries were caused by falling from motorcycle, but it was clear from the MLC report and testimony of prosecution witness 4, an expert doctor, that injuries were caused by hard and blunt objects like lathi. Seventh, delay in filing FIR. So, in case of Amar Singh versus Balwinder Singh and others, Supreme Court held that delay in lodging FIR would not automatically render the prosecution case doubtful. Lastly, defense stated that victim prosecution witness 1, the complainant himself, and prosecution witness 3, real brother, are habitual offenders is completely irrelevant and groundless. As per section 49 of Bharatiya Sakshi Adhiniyam, previous bad character in a criminal proceeding is irrelevant and thus needs to be disregarded. Thus, finally, prosecution discharged its onus of proof successfully by rebutting all the defenses. So I request Honorable Court to convict the accused for their acts. Thank you.
Defense clause is that on 13/11/2024 is a public holiday is very relevant to the case because this show the Bittu dishonestly to the case from very starting. In the prosecution cross argument said that Bittu is a municipal officer, but this do not affect the matter because there was no one in the office on that day. Next defense against the prosecution clause is prosecution advocate admit that the prosecution witness 2, prosecution witness 3 are the relative witnesses and their statement cannot be disregarded only for that reason, but Honorable Court, this can make the case biased, impartial and required to be test reliability and credibility of the witness to the cases. Testimony of the witness 1, witness 2, witness 3 are totally in the question for launching false case and they conspire the case very cleverly. And so I requested to this court not to dismiss the plea of alibi of under section 9 of PSA. Next defense against the prosecution clause is, sir, I agree driving license of a Bittu is not directly fact and issue, but it cannot be denied that the driving license is a relevant fact under section 4 of BSA as closely connected fact. Section 4 of the BSA states that the facts which are not fact and issue are so connected with the fact and issue as to form the part of same transaction are relevant whether they occurred at same time, same place or at different time and different place. So in the last we cannot unnoticed that recently on 25/11/2024 Bittu purchased a new bike and do not have any driving license. Next clause of defense is that prosecution argument impose a charges of section 117 subclause 2, section 115 subclause 2 voluntary causing grievous hurt and voluntary causing hurt respectively. My lord, how it is immaterial and only a clerical error, no more than that, because injury caused during this incident are the fact and issue. Next clause, in cross examination The prosecution advocate is stating that the injuries were caused by the hard and blunt object like lathi, but I want court to focus on that. In investigation proceeding, there was a fingerprint, but according to forensic report, no fingerprint of the accused 1 and accused 2 found on lathi. This shows the injuries are caused due to the any other reason like falling from the height. My next defense against the prosecution cross is delay in the lodging FIR would not automatically render the prosecution case doubtful as a prosecution cross, but it cannot be denied the fact that it gives the time to the complainant to plan this case. In the last, so I kindly requested this court to acquit my client from the false allegation because all allegations are meaningless, unreasonable, misleading the court and total waste of time. Defense counsel have full faith on this court that Amit and Arun get justice. Thank you. No further question and please. Thank you.